May I just make a short response to that?
Proceed.
My problem with that, Your Honor, is it deals with the acquisition cost. In the first place, the witness, Your Honor, is not a party to the sale. He would not know what the acquisition cost is.
But the
Mr. President,
is referring to the mandate of the law, and that pertains to his function as an assessor. And he is being asked whether the owner of the property complied with that requirement. So he may answer.
Your Honor, as of today, I have no knowledge since this honorable impeachment court honors only subpoenaed documents pertaining to tax declaration per se.
Mr. President,
The majority floor leader.
may we recognize the son of the author of the local government code, Senator Coco Pimentel, to enlighten the gentleman on the floor.
The gentleman from Mr.
Thank you, Mr. President. Just to be fair to the witness also, and for the information of the prosecution, attorney, please pay attention. You require the witness to read sections 202 and 203.
That is correct, Your Honor.
But you also read section 204.
That is correct, Your Honor.
203 says that this is the duty of the person acquiring. But section 204 says that if that person does not discharge his duty, then it's the assessor himself who will now make the declaration so that they can complete the schedule of values.
Correct, Your Honor, but there is nothing which prevents the owner from, after a tax declaration is issued, from divulging
Yes.
the true cost, the true value of his property.
But my point is, to be fair, no, you also ask him to read 204, because although 203 uses the word duty, it's not such a big deal if the duty is not complied with, because 204 has the mechanism to correct the situation when the people do not discharge this particular duty. So,
may I have permission to ask the witness to read into the record section 204, Your
Thank you.
Honor. In compliance with the request of Senator Judge Pimentel. Mr. Witness, can you please read into the record section 204 of the Local Government Code?
Section 204. Declaration of real property by the assessor. When a person, natural or juridical, by whom real property is required to be declared under Section 202 hereof, refuses or fails for any reason to make such declaration within the time prescribed, the provincial, city, or municipal assessor shall himself declare the property in the name of the defaulting owner, if known, or against an unknown owner, as the case may be, and shall assess the property for taxation in accordance with the provision of this title. No oath shall be required of a declaration thus may be made by the provincial, city, or municipal assessor.
Thank you, Mr. Witness. Again, let me ask you, Mr. Witness, was there or was there not any declaration made by CJ Corona on the true value or the actual value of the properties that he acquired in your jurisdiction?
Your Honor, please, the question will lack basis, because not all the properties involved in the declaration mentioned, Your Honor, belongs to the Chief Justice, Your Honor. The other property belongs to Karina. How can the Chief Justice be made to account for that?
I am going there, Your Honor.
Go over the property one by one. The presiding officer would like to ask this question. Would the office of the city assessor of Taguig issue an assessment without the required declaration, the declaration required under the local government code?
There are cases, Your Honor.
When
when the owner fails to declare his property, Your Honor.
And you make the declaration.
Yes, Your Honor.
But in all cases, a declaration must be made, whether by the owner or by the city assessor, as a basis for the issuance of an assessment of the property for the owner to pay the real estate tax.
Yes, Your Honor.
Correct?
Yes, Your Honor.
So once
Thank you.
an assessment is made, the assumption is that there was a proper declaration done for that particular property.
Yes, Your Honor.
All
We
right.
made our assessment based on the schedule of fair market
Okay.
value.
Your Honor, may
Go
I
ahead,
interrupt
Mr.
for a minute, Your Honor?
Oh.
I'd like to cite the resolution adopting the rules of procedure on impeachment trials. Rule 15, may I read? Witnesses shall be examined by one person on behalf of the party producing them, and then cross-examined by one person on the other side. I noticed, Your Honor, that there was a substitution of counsel on the part of the defense.
May I reply, Your Honor?
Yes, please.
Accidentally enough, Mr. Counsel, I am the lead counsel of the Chief Justice. And I can take over any time with the permission from the Honorable Court. Is there any violation of any rule?
Unfortunately, the rules...
What the rules provide is if at the same time two or more. If it is
No,
one
no.
by one, there is nothing mentioned.
I have to stop this. You're quibbling with inconsequential matter.
Yes.
We
It doesn't
submit, Your
matter
Honor.
whether the one that asked the question is either way. The panel of defense is there, the panel of prosecutors there. You deal with the witness.
We submit, Your
You're
Honor.
delaying the proceeding.
We apologize, Your Honor.
Stop this thing so that we can proceed.
I have a pending question with the witness.
Go ahead.
Did Mr. Corona file or did he not file the required sworn statement under Articles 202 and 203 of the Local Government Code with respect to his properties in Taguig City?
Your Honor, please, it assumes a question that...
Witness may answer if he knows.
As of today, I have no knowledge about
Oppose.
the Chief Justice files
Can
his sworn
you,
statement. Your
Mr.
Honor.
Witness, can you please make a definitive answer?
Well, as of today, he does not know. Don't press an answer of knowledge when the witness has already said, as of today, he does not know.
Your Honor, may we allow the witness to go back to his office and come back maybe on Monday and bring a certification that there is no such filing on the part of the Chief Justice, or if there is one, please bring a copy of the sworn statement.
Your Honor, please, may I be allowed?
Yes, please.
All right. Your Honor, please, that assumes a situation where the procedure being laid down by the Honorable Counsel, Your Honor, is supposed to be mandatorily or to be observed in all cases, Your Honor. What the law says, if the owner or the administrator fail to make the necessary declaration under oath within 60 days after the acquisition, Your Honor, then the office of the assessor can continue with the proceedings and make the assessment instead of the owner or the administrator, Your Honor. Why will there be a necessity? There is no procedure that is outlined for that purpose, Your Honor. That is an arrogation of the power that do not belong to this witness, Your Honor.
May I respond to that very briefly,
Yes,
Your
go
Honor?
ahead.
The Local Government Code mandates it's not an option on the part of the owner, because the wording is it shall be the duty. It's a mandatory provision, Your Honor.
What is the... May we know the purpose? I was telling you, Your Honor, that it is directed towards...
Are you, counsel, disputing the accuracy of the assessment issued on these units by the city assessor of Taguig?
Your Honor, there is a big discrepancy between the market
Well,
value.
then, if you have the evidence, produce it.